My name's Graham Pepper, and I'll be the presiding judge today. Prosecution, are you announcing ready?
Yes, Your Honor, the prosecution is ready to proceed.
And defense, are you announcing ready?
Yes, Your Honor, the defense is ready to proceed.
I now need to confirm that video recorders are present and being used. Both teams have approved the taping of this round, is my understanding. The Colorado Bar Association may be taking photographs of the competition during the round, and that team participation in the state tournament grants automatic permission and use of these photos by the Colorado Bar Association. Anyone that's in the gallery that's connected with the teams that's not competing in this round, student members and coaches of other schools or of the same school but a different team, need to leave the courtroom at this time. There is no recesses that will be allowed during this trial, with the exception of those granted for a health emergency, and especially not between the end of a witness examination and the beginning of closing arguments. Each scoring panelist that we have, could you introduce yourselves?
My name's Thomas Nolan, and I'm an attorney who's practiced in Jefferson County for over 30 years.
And
my name is Rebecca Taylor. I currently work for Arapahoe County as an assistant county attorney doing civil defense litigation.
Mr. Honegger?
Good afternoon, everybody. Eric Hohenegger. I am in private practice, and I currently have I practice in the area of divorce, domestic relations, and also dependency and neglect. Some minor criminal too.
Do any of the panelists have any concern that you may have a conflict, that you know somebody in this on one of these teams?
No.
I do not.
And prosecution, would you introduce your prosecution team?
Yes, Your Honor. Your Honor, members of the jury, good afternoon. My name is Anna Debler, and today I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Taylor Perkins, and providing the opening statement.
And can you introduce
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Kaylee Langen, and I will be providing the direct examination of Alex Cifuentes and the cross-examination of Avery Becker.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Anjali Mishra, and I will be providing the direct examination of Kyle Cusack, the cross-examination of Blake Van Owen, and providing the closing arguments for the prosecution. Your Honor, at this time, we ask that our witnesses please be allowed to introduce themselves.
Yes, please.
Good afternoon, Your Honor, members of the jury. My name is Hannah Moskowitz, and today I am Jordan Markowitz.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Maggie Holland, and today I am Alex Cifuentes.
Good afternoon, Your Honor. My name is Raina Hilden, and I am Kyle Cusack.
Thank you. And now may the defense please introduce themselves.
Good afternoon, Your Honor, opposing counsel. My name is Forrest Williams, and I am Taylor Perkins.
Good afternoon, Your Honor, ladies and gentlemen of the jury and opposing counsel. My name is Haley Glass, and I will be performing the cross-examination of Jordan Markowitz and the direct examination of Avery Becker.
Good afternoon, Your Honor. My name is Eliza Bachner, and I will be directing Taylor Perkins and crossing Alex Affrontus, and I will be providing the opening statement.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Sophie Lehman, and today I will be performing the direct examination of Blake Van Owen, the cross-examination of Kyle Cusack, and the closing argument. We now ask that our other two witnesses be allowed to introduce themselves.
Please. Mr. Massaro, you have significant feedback.
Good evening, Your Honor, ladies and gentlemen of the jury. My name is Colin Blackford, and I am Avery Becker.
Would you like for us to have Mr. Musar reintroduce himself?
If he could, I could not hear it. I don't know if he has two microphones going on at once.
He's in the courtroom.
Yeah, that's what the picture says.
He's in the courtroom, yeah.
Your Honor, we ask that Mr. Musara be allowed to introduce himself in the chat since we can't hear him.
That is fine. And Mr. Massaro, I got to tell you, I'm the last person to give anybody technical advice. I will tell you, when I get bad feedback, I usually have two either microphones going or two speakers going at once. So in other words, your computer speaker and your like monitor speaker both on at the same time. So maybe check those things. And may I go to the next witness, please?
I believe all of our witnesses have now introduced themselves.
And then we'll continue to proceed. The teams and coaches, if there's any disputes arising out of this competition, they must be reported in accordance to the rules with the competition rules. Your compliance with the rules will be part of your scoring of each individual performance. And does the prosecution have a timekeeper?
Yes, Your Honor.
Thank you. And does the defense have a timekeeper?
Yes, Your Honor. Her name is Kendall Dale in the chat, just so you know.
Okay. If everyone, all the attorneys and witnesses, if they could turn on their video and raise your right hands, please. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? And witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem and that will follow the rules and procedures of the mock trial competition? Gallery members, including teacher and attorney coaches, family members, and friends, please raise your right hands. Do you promise to represent yourself as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial?
I do.
I do.
Scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
I do.
Thank you. Prosecution, you may proceed.
Your Honor, just briefly, the prosecution has a few pretrial matters to address.
Please go.
Your Honor, the prosecution would ask that any time left over from the prosecution's closing argument would be reserved for rebuttal.
Granted.
We would also ask that all of the witnesses except the defendant would be constructively sequestered.
That's granted.
Your Honor, we would also ask that the prosecution and the defense would have permission for trial technicians to display exhibits on the screen for purpose of entering them into evidence, or if they have already been entered into evidence for expedience sake.
Granted.
Also, Your Honor, as exhibits are initially displayed on the screen, the prosecution would ask that it would be recognized that this is just to display the exhibit to the witnesses and opposing counsel, not to the jury until the exhibits have been published.
And that is granted. Thank you.
And lastly, the prosecution would ask that the exhibits, once they have been entered, would be constructively published to the jury, but just remain on the screen.
They will be published.
That is all from the prosecution. We would ask that these would be granted to the defense as well.
They are granted to the defense as well. And defense, do you have any additional requests?
I only have one additional request, and that is for the time to be paused if any technical difficulties do occur, given the format of this trial.
The time will definitely be paused for that.
Thank you, Your Honor. That's all.
And the prosecution, please proceed to opening arguments.
Yes, Your Honor. May it please the court. Your Honor, members of the jury, my name is Anna Debler, and along with my co-counsel, Anjali Mishra and Kaylee Langan, today I represent the state of Colorado to bring forth the charges of murder in the first degree and burglary in the second degree against the defendant, Avery Becker, and prove beyond a reasonable doubt that the defendant is guilty in this case. Members of the jury, this is a case of the defendant's revenge gone wrong. For the past couple of years, the head of the Colorado High School mock trial team and litigator, Mr Brockman, volunteered his time with students. However, you will learn from the evidence provided today that one student in particular had a contentious relationship with the coach. Avery Becker, a senior on the team and the defendant in today's case, is very passionate and skilled in mock trial. The defendant argued frequently with Coach Mr Brockman about his coaching style. The defendant arrived at practices and trials unprepared, and Coach Brachman disapproved of this. Because of this behavior, the coach even demoted the defendant to the B team, angering the defendant. You will learn from testimony today that this relationship took a turn for the worst when the defendant vandalized Coach Brachman's vehicle after a heated argument at the regional mock trial competition. The coach then kicked the defendant off of the team. You'll hear today that the defendant pleaded with their teammates, including Alex Cifuentes, for help to get back on the mock trial team. With no success, the evidence will show that the defendant sought revenge on the coach by breaking into the coach's home. However, the evidence will show that this revenge went wrong. On Friday, March 6th, 2020, Coach Brachman was found dead just inside the doorway of his own home. The police concluded that the defendant, Avery Becker, killed the coach. Now today, members of the jury, the prosecution will call 3 witnesses who will provide testimony and meet the burden of proof in this case. The prosecution's first expert witness, homicide detective Jordan Markowitz, will take the stand. You will hear from Detective Markowitz that they have a firsthand knowledge of the crime scene. You'll learn how the detective obtained forensic evidence, ring videos, cell tower records, and phone records, all of which tied the defendant to Coach Brachman's home at the time of the murder. Then, the prosecution's second expert witness, investigator Kyle Kuzak, will provide testimony. You will learn that the investigator also has firsthand knowledge of the crime scene. And on the stand, she will confirm Markowitz's findings through methodically collected evidence that describe a struggle as the defendant entered the mock trial coach's home, was surprised that the coach was home, and stabbed the coach. Third, Mr. Alex Cifuentes will take the stand. You will hear that Cifuentes, a senior at Colorado High School, was a member of the mock trial team, observed the tension between the defendant and the coach, and will most importantly provide screenshots of a conversation with the defendant. This evidence will show that the defendant had intent to trash the coach's house. However, that revenge of burglary and vandalism went wrong and instead ended with the death of Coach Brachman. And jury members, be wary of the defense's witnesses. Listen closely to their testimony and look out for bias that they might include. The evidence provided today will detail that none of the defense's witnesses were at the scene of the murder, and none of the defense's witnesses can provide a solid alibi for the defendant at the time of the murder. And at the end of today's trial, my co-counsel, Anjali Mishra, will take the stand to give the prosecution's closing argument. She will remind you of the important details of the trial that will prove the defendant's intent and meet the prosecution's burden of proof. She will point to this being a case of the defendant's revenge gone wrong, resulted in the murder of Mackenzie Brachman. Members of the jury, we ask that you return a verdict of guilty. Thank you.
Thank you. And now does the defense have an opening argument?
Yes, Your Honor, we do. May I continue? May it please the court. Good afternoon, Your Honor, and members of the jury. I am here on behalf of my client, Mr. Avery Becker, who's been wrongfully accused of murder in the first degree and second-degree burglary. Today, the evidence will prove that this man is not guilty of the charges filed against him. You will see that the prosecution's case is simplistic, superficial, and speculative. The prosecution has won a simple case. You will hear Detective Markowitz testify that the first and only suspect was concluded to be the murderer without further investigation or conclusory evidence. This makes their case, too, superficial. The police performed a superficial investigation and barely skimmed the surface of the available and relevant evidence. The prosecution's investigation started with an interview of one of the victim's students. Listen to this student, Alex Cifuentes, who provided the police with a suspect. However, this student was jealous of Mr. Becker and had motive to cause trouble for him. The police then proceeded to name Mr. Becker the culprit. However, they did not further their investigation and questioning of other students, teachers, people Mr. Brachman worked with, and neighbors who may have witnessed the murder. Detective Markowitz will tell you that the police did not investigate other suspects, including Blair Rollins, a student who had a grudge against Mr. Brachman, who was the same build as Mr. Becker, who was missing the day from school, the day of the murder, was friends with the student who had Avery Becker's phone the night it went missing, and finally, who coincidentally vanished from Colorado after the murder. You will hear about cell data evidence from the time of the murder, but listen carefully for evidence from the time before the murder, the day of the murder, and days after to find a user and location of the phone. The evidence of this case is 3, speculative. The prosecution's burden, beyond a reasonable doubt, is the heaviest of burdens. Avery Becker's phone, a critical factor in this case, went missing the night before the murder and was not recovered. It is unknown who had the phone the day of, the day before, and days following the murder. And to this day, it is still missing. You will hear about the text purportedly sent between Avery Becker and Alex Cifuentes. But notice that Alex Cifuentes' phone is never produced. The police never investigated that phone, nor even saw the text to prove their authenticity. The crime scene reconstruction created by Mr. Cusack is a detailed analysis of the murder, yet fails to decisively implicate a specific culprit. You will not hear about any evidence that ties my client to the scene of the murder. Indeed, the evidence produced by the Ring doorbell videos instead proves that it is impossible to tell who the intruder is. For the defense, you will hear from Avery Becker, who's been wrongfully accused of murder in the first degree and second degree burglary. You will hear that he and Mr. Brachman had a contentious relationship, but his conflicts were a far cry from murder. You will also hear from Taylor Perkins, who provides Mr. Becker with an alibi for the entire day of the murder. You will also hear from Professor Van Owen, a private investigator and an expert witness in cases across the country in both crime scene reconstruction and cell tower analysis. He will debunk the police's theory and with solid evidence and no ulterior motive. Definitive facts of this case are that on March 6, 2020, someone broke into Mackenzie Brachman's house. And at some time when that person was in the house, Mr. Brachman was stabbed in the back and he died. It is a tragedy, but one that my client had none to do with. The prosecution has a simple case, superficial investigation, speculative evidence. The prosecution cannot confirm that Avery Becker committed this crime. So I ask for you to find the defendant not guilty of these charges. Thank you.
Prosecution, do you have your first witness ready?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
Please proceed.
Hello, Detective Markowitz. Can you please state your name and spell your last name for the record, please?
Of course. It's Detective Markowitz. Last name spelled Markowitz.
And can you tell the jury a little bit about your employment history, please?
Of course. I've been a
Would the witness please move a little closer to the microphone, if possible?
Yes, of course. Can you hear me better now?
A little bit.
Okay. I'll try and project as much as possible.
Okay, thank you.
I've been working with the Denver Police Department for the past 13 years. However, for the past 7, I have been a detective there.
And do you have any special training in certain fields?
I do. I received training in cell phone technology and forensic data recovery from the American Academy of Law Enforcement.
Can you please elaborate on that training a little bit?
Of course, it was a 3-day training course in which you had to pass a certification test in order to pass the class.
And Detective, do you use this training in the field regularly?
I do. I've used it in over 50 cases that I've worked on. Your
Your Honor, at this time, I move to tender Detective Markowitz as an expert in the field of cell phone technology, forensic data recovery, and criminal investigation on the grounds of her skills, training, and experience under Rule 702.
Ms. Glass, your position,
I just have a brief voir dire, Your Honor, if that's all right.
please.
Ms. Markowitz, is it true that you only had 3 days of training in order to get your certification on cell phone technology?
Well, it's only 3 days. I do have a passion for cell phone technology and forensic data.
Ms. Markowitz, my question wasn't about your passions or your experience. My question was if the training was only 3 days.
It's 3 days, but I've used it in over 50 cases and I continue research on my own time.
Thank you, Ms. Markowitz. That should suffice. Is it also true that cell phone analysis is not an exact science, or in other words, you can't always be certain that your analysis is true?
Well, that is true. However, I do have a lot of faith in it, and it did help substantially in this case.
Moving forward, the algorithm used for cell phones to pair with a tower is also an extremely complicated one, isn't that correct?
Well, yes, but they did cover that in a 3-day course.
Your Honor, I don't believe that her personal beliefs are sufficient enough for her to be entered in as a witness, so I object to Markowitz being entered as an expert in the field of cell phone technology due to her limited 3-day training in the field, and the fact that cell phone analysis is not a precise enough science to be able to draw conclusions that she may attempt to with the name of an expert. Apologies, Your Honor, I believe you're muted.
Boy, I gotta tell you, this mute button is far more complicated than one can imagine. The witness will be tendered as an expert as tendered, and the objection is noted.
Yes, Your Honor. Now, Detective, what was your role in today's case?
Well, I went to the residence of the victim, Mackenzie Brachman, on March 6, 2020 at 2:20 p.m. at the residence 444 South Flower Street in order to investigate the murder.
And what did you conclude about today's case?
Well, I concluded 3 things. The first being that the defendant had the intent to vandalize the home of Mr. Brachman. The second, the victim, Mackenzie Brachman, died in a struggle. And the third, the defendant was at the home of the victim, Mackenzie Brachman, as seen through the cell tower records.
Now let's look at the first conclusion. What did you do upon arriving at the scene of the crime?
Upon arriving at the scene, I entered through the back door and made my way through the front of the residence, where I saw the victim, Mackenzie Brachman, face down in a pool of his own blood.
Your Honor, at this time, let the record reflect that our trial technician will be displaying exhibits 1, 2, and 4 on the screen. Now, turning to exhibit 1, Detective Markowitz, do you know what these exhibits are?
I do.
And turning to exhibit 1, what is exhibit 1?
Exhibit 1 shows a picture of the victim as seen from the front view of the porch in his home.
Now, turning to exhibit 2, what is exhibit 2, Detective?
Exhibit 2 is another picture of the victim, this time in relation to the door, as well as a better image of the wound on his back.
Now, looking at exhibit 4, what is exhibit 4?
Exhibit 4 gives us the clearest image of the victim's stab wound on his left shoulder.
And are these all fair and accurate copies of what you saw on the scene on March 6th, 2020?
Yes, they are.
Your Honor, at this time, I move to enter exhibits 1, 2, and 4 into evidence.
And Ms. Glass, your position?
I have an objection, Your Honor, on the grounds of more prejudicial than probative under Rule 403. These images could be misleading to the jury by just showing the goriness of the crime scene without indicating any physical or hard evidence that could tie my defendant to the crime scene. They are also a needless presentation of cumulative evidence, given that there is 4 pictures that do the same as one could cover.
Overruled. The pictures will come in as evidence.
Yes, Your Honor. Now turning to exhibit 4, Detective, what was the importance of exhibit 4 specifically?
Well, since this image gives us the best view of the stab wound on the victim's upper left shoulder, it shows us that there was indeed a struggle as indicated by the horizontal mark left by the knife.
And from this physical evidence, what did you believe to be the progression of events in today's case?
I believed that the victim, Mackenzie Brachman, was running away from the intruder when a struggle ensued and he was ultimately left dead.
And turning back to exhibit 1, what else did you notice about the residence?
Well, as seen in the upper right-hand corner of exhibit 1, you can see a ring doorbell, which was very important for this case.
And were there any more ring doorbells on the property?
There was. There was also one on the side of the house as well as the rear of the house.
And Detective, did you use those ring cameras in your investigation?
I did. I illegally accessed several videos which showed an intruder coming in with the same build and height as Avery Becker, first trying to attempt to enter the residence through the front door. When that did not work, the intruder, Avery Becker, went around back and entered the back home of the residence, ensuing in a struggle with Mr. Brockman before exiting the front door.
And now let's talk about that second conclusion you reached about Avery Becker's intent. Was there any other evidence to point to Avery Becker as the murderer?
Yes, there was. After doing more research into the victim, Mackenzie Brachman, I found that he was a high school mock trial coach. This led me to one of his students, Affrontus, who I contacted and provided me with screenshots in which the defendant, Avery Becker, clearly stated his intent to vandalize the home of Mr. Brachman.
And what did you do to investigate the detective further? Or the defendant further, excuse me.
Well, I was refused an interview with Avery Becker. Therefore, I received warrants to gather cell tower records from the defendant's cell phone.
And Detective, can you please explain to the jury in layman's terms what those cell tower records were?
Of course. I mean, I could go on for hours about cell phone technology. However, I'll keep it brief. CDRs, or call detail records, are records pulled from cell towers that show incoming and outgoing calls and texts, their duration, the date and time these interactions were made, as well as which tower they were connected to.
Now, let the record reflect that the trial technician is displaying exhibits 15 and 16 on the screen. Detective,
record will
are
so-
yes, Your Honor. Oh, yes.
The record will so reflect.
Yes, Your Honor. Detective, what are exhibits 15 and 16?
Both of them show the towers that Avery Becker's phone connected with, and 16 also has a dotted line indicating the determined path of the defendant.
And do you often compile data in this way?
I do.
And are these fair and accurate copies of your records?
Yes, they are.
Your Honor, at this time, I move to enter exhibits 15 and 16 into evidence.
Ms. Glass, what's your position?
I'd like to object on the grounds of cumulative. Once again, they could cover what they're going to talk about with just one of these images rather than both.
They'll be admitted for the purposes as stated, both exhibits.
Yes, Your Honor. Now let's talk about your third conclusion, Detective, that pin Becker's record to the scene. Now, using exhibits 15 and 16, can you please tell the jury what the CDRs indicate about Avery's cell phone activity on March 6th?
Of course, going with the times that Avery Becker's phone connected to certain antennas, I determined that from 12:45 to 12:50, Becker was at his home, then driving towards Brachman's house, and from 1:05 to 1:17 p.m., Becker was at Brachman's home, as indicated by its connection to the antenna 1197-1.
And Detective, finally, in your expert opinion, what happened in today's case?
To me, it is absolutely clear that Avery Becker, intending to vandalize the home of Mackenzie Brachman, entered his residence, and upon finding them there, panicked and murdered him in cold blood, an act of revenge gone wrong.
Thank you. No further questions, Your Honor.
Cross-examination,
Yes, Your Honor. May I proceed?
you may.
Good evening, Ms. Markowitz. Now, let's get straight into it. You knew the victim prior to this investigation, is that correct?
Yes, I did. However, I would prefer if you called me Detective Markowitz.
Apologies, I will refer to you as detective from now on. Detective Markowitz, you thought that Mr. Brachman took cheap shots when it came to his work, is that correct?
I did believe that, yes.
Moving forward, from the evidence you analyzed, this appeared to be a break-in gone wrong. Is that also true?
Well, that was my initial conclusion. However, other evidence led me to believe that it was Avery Becker who, in fact...
Miss Markowitz, my question did not have anything to do with Miss Becker or who was guilty of this crime, but simply if, from the evidence you analyzed, if this appeared to be a break-in gone wrong.
That was my thought, yes.
Moving forward, you also believe that there was a possibility that this could have been the work of a disgruntled ex-client. Is that true?
Again, that was one of the possibilities I considered early on in the investigation. However, all other evidence pointed to Avery Becker.
My question once again had nothing to do with Miss Becker, but just to reiterate, you did think this could have been the work of a disgruntled ex-client, yes or no?
That was my initial belief.
Sorry, I still did not hear a yes or a no.
Originally, yes.
And you believe this was an important factor to consider, is that correct?
Yes, it was.
Yet you did not investigate this alternative, is that correct?
No, as I said, the progression of the investigation led me to believe it was Avery Becker.
And once you arrived at the house to do your investigation, the house was in a disarray, correct?
Yes, it was.
But there was no way for you to determine whether this was due to the break-in or the normal state of the house, is that true?
That is true.
In your initial investigation, it seemed very unlikely that Mr. Brockman's death had anything to do with his role in mock trial. Is that true?
Well, in my initial conclusions, I did not know he was a mock trial coach. However, upon further investigation, it was determined it was Avery Becker.
Miss Markowitz, my question did not have anything to do with Miss Avery Becker again, and I'd like you to answer this question with a yes or no. In your initial investigation, it seemed very unlikely that Mr. Brockman's death had anything to do with his role in mock trial. Is that correct?
Initially, yes.
When you interviewed Cifuentes, is it true that she conveniently forgot to bring her cell phone?
Yes, it was.
So as an alternative to investigating the cell phone yourself, you had Cifuentes submit screenshots of the conversation she had with Miss Becker.
Yes, I had her do that.
And there were no timestamps included with these messages, is that correct?
No, there were not.
So there's no way for you to ensure when these text messages were sent or who they were sent by.
No.
Furthermore, even as an expert, you would say that the system in which a cell phone pairs with a tower is a very complicated algorithm. Is that correct?
That is correct. However, I did go over it in the training course.
But it is true that sometimes the best tower is not always the nearest tower, so the cell phone does not always connect to the nearest tower.
But majority of the time it does.
I'm sorry, can I just get a clear yes or no answer for the record?
That is true.
The CDRs in this case indicated that Becker did not respond to any texts or phone calls on March 6th. Is that also true?
That is correct.
So as an expert, you can conclude that Becker was not using her phone at this time.
Well, I considered Becker to be a little busy murdering Mackenzie Brachman, so would be.
My question had nothing to do with murder. It simply had to do with whether Miss Becker was on her phone or not and the idea of cell phone technology. So can you answer that question using your expertise?
Well, Becker was not on his phone. That is correct.
Thank you. Is it true that you can't be 100% certain that the communication with Avery's phone indicated that she was driving along Rock Creek Parkway due to the complicated algorithm we previously talked about?
No, it is very hard to say with 100% certainty.
You believe the victim had interrupted what was thought to be a robbery gone wrong, correct?
That is correct.
Was anything taken from the house on March 6th?
No, as a robbery gone wrong, it left in murder and not an actual robbery.
Moving forward to those Ring doorbell videos you were referring to, could you identify the race of the person in these Ring videos?
No.
Could you identify the gender of the person in these Ring videos?
No, you cannot.
Can you identify the age of the person in these Ring videos?
No, you cannot.
Can you identify anything about the intruder besides an approximate height and build?
No, you cannot.
One final question, Ms. Markowitz. Do you have any hard or physical evidence to tie my client to the crime scene, or is it all just ideas?
Well, I do believe the CDRs provide very good evidence that Becker was at Brachman's home.
But you believe even those cannot show 100% certainty that Becker was at the crime scene?
Well, nothing shows 100% certainty. But
no further questions, Your Honor.
Any redirect?
Your Honor, just briefly. Detective Markowitz, what other evidence did you have to prove that Avery Becker was the most likely suspect in this case?
Well, again, the call detail records was the main piece of evidence, and it was merely built up by other evidence such as the matching height and build in the video, as well as the intent through the text messages shown.
Thank you, Detective. No further questions, Your Honor.
Any questions based off the redirect?
Just one brief one, Your Honor. Ms. Markowitz, you claim that the CDRs were the most valuable piece of evidence, but yet, do you still believe that they are not 100% accurate?
Again, nothing is 100%, but 99%.
No further questions, Your Honor.
Prosecution, who is your next witness?
Your Honor, the prosecution calls Kyle Cusack to the stand. May I proceed?
You may proceed.
Yes, Your Honor. Good afternoon, Ms. Cusack. Can you please state your name and spell your last for the record?
Yes, of course. My name is Kyle Cusack, K-U-Z-A-K.
Now, can you please tell the court a little bit about your professional background?
Yes, of course. I am a crime scene reconstructionist, or CSR for short, and I have 19 years of experience in my field.
Now, Ms. Cusack, what exactly is crime scene reconstruction?
So, at its base, crime scene reconstruction is just connecting pieces of evidence that we find at various crime scenes and using those to find out which events actually led to the results. So, in this case, what happened between the perpetrator entering Mackenzie Brachman's home and his eventual death.
Where do you work currently?
For the past 3 years, I have been a civilian employee of the city of Denver.
And what have you investigated over your career working for the city of Denver?
I've definitely investigated a pretty decent variety of crimes, everything from homicides similar to this one to burglaries, armed robberies, things like that.
And what kinds of processes do you use in these types of investigation?
I break down my process into 5 steps, those being recognition and documentation, evidence collection, evaluating the evidence, hypothesizing and testing, and then finally publishing my final report.
And are these methods widely used in your field by other experts?
Yes, of course. This similarly follows the Bevel-Gardner methodology, as well as just following the general principles of the scientific method, which have been accepted for centuries now.
Your Honor, at this time, the prosecution moves to tender Ms. Kyle Cusack as an expert in crime scene reconstruction.
Defense, any position?
No voir dire, Your Honor.
Go ahead.
Excuse me, sorry. What did opposing counsel say? I could not hear. You broke up.
Is opposing counsel on mute?
I just said no voir dire, Your Honor.
Any position on the on her expertise?
I'm
Is
sorry.
Sorry.
What was that, Your Honor?
Any position on her expertise? Any objection or no objection?
No objection. Everything I have to say will be covered in cross-examination.
The witness will be tendered as offered.
Yes, Your Honor. Now, Ms. Cusack, how are you involved in the case today?
Well, I had personally visited the crime scene on March 6th, 2020, and was the main crime scene reconstructionist on this case.
Now, can you break down a little bit more in depth for the jury? What was your process for this crime scene reconstruction?
Well, of course, I follow my standard method and principles. I assume every single case I take part in will go to trial. So I very thoroughly document all of the witnesses, evidence, and theories that I have along the way before coming to my final peer-reviewed report.
Now, is this process, standard to your field of work?
Yes, of course. I mean, thorough documentation is essential to any scientific field, and I quite frankly wouldn't trust a reconstructionist who didn't do so.
And is your work peer-reviewed?
Yes, of course. That is essential.
Now, allow me to direct you to Exhibit 17. Do you recognize the exhibit? And I believe the trial technician will be putting it up.
Yes, I do recognize this.
What is this exhibit?
Exhibit 17 shows my witness and evidence tracking sheets, as well as the flow chart I used to demonstrate the events.
And how do you recognize this exhibit?
I made this work myself.
And is this part of your regular methodology in investigating these cases?
Yes, this is standard for my documentation process.
And is this commonly used in your field by other experts?
Yes, of course. As I said earlier, I wouldn't trust a reconstructionist who didn't thoroughly document everything they came across.
And is this a true and accurate copy of your work?
Yes.
Your Honor, at this time, the prosecution moves to enter Exhibit 17 into evidence.
Defense's position?
No objections, Your Honor.
Those shall be admitted.
Yes, Your Honor. Now, can you explain, referencing this exhibit, what happened during this home break-in at its base?
Well, we can see the 4 major points of this being the perpetrator entering the victim's residence, the victim eventually being notified of this entrance, and using this diagram, you can see the color coding for each major step. The perpetrator finally entering the victim's residence, and the 2 engaging in a fight, which ends in the victim being stabbed and tragically dying from that wound.
Now, let's break that down a little bit more step by step. What occurred as the home was actually broken into?
Well, we saw from the ring security videos that the perpetrator first attempted to enter through the front door and eventually through the back. when that person had realized that the front door was locked. And we also see through these videos that the perpetrator entered unarmed.
Now, what happened after that?
Well, the victim had evidently noticed that somebody was attempting to enter his home, either through the Ring security system or simply by hearing somebody attempt to enter the front door.
Now, was there any evidentiary ground for a struggle occurring in the kitchen?
Yes, of course. We saw near the back door incredibly significant scuff marks, as well as a broken plate, and obviously the victim's final injuries.
Now, allow me to direct you to exhibits 9 and 18. Do you recognize these exhibits?
Yes, I do.
What are they?
Exhibit 18 shows the scuff marks near the back door, and Exhibit 9 shows the broken plate in the kitchen.
And how do you recognize what these exhibits are?
I observed these myself at the scene of the crime.
Are they fair and accurate representations of what you saw at the crime scene?
Yes.
Your Honor, at this time, the prosecution moves to enter exhibits 9 and 18 into evidence.
And the defense's position.
No objections, Your Honor.
They shall be admitted.
Yes, Your Honor. Now, Ms. Cusack, why were these pieces of evidence important to your case?
Well, knowing what happened between the perpetrator and the victim that led to the death is incredibly significant, because this helps us understand how the perpetrator who entered unarmed eventually killed somebody. So in this, we know that the two entered into a physical fight with each other.
Now, let's talk a little bit about the knife or murder weapon specifically. Where did this knife come from?
Well, in an attempt to defend himself, the victim had grabbed a knife from his knife block, and that during the fight between the perpetrator and victim, the perpetrator eventually took hold of the knife and stabbed the victim in a sort of bear hug.
Now, allow me to direct you to exhibits 5, 6, 7, and 8, which the child technician will be screen sharing. Now, do you recognize these exhibits in front of you?
Yes, of course. Exhibits 5 and 6 show the knife, which was the actual murder weapon, and exhibits 7 and 8 show the knives in the victim's home.
Now, how do you know what these exhibits are?
I had observed all of these things during my time both visiting the crime scene, and Exhibit 6 came from the lab where we did our analysis.
Now, are these pictures fair and accurate representations of what you saw at the crime scene?
Yes.
Your Honor, at this time, the prosecution moves to enter exhibits 5, 6, 7, and 8 into evidence.
Defense position.
Yes, I just have a couple of objections, Your Honor. In regard to the two photos depicting the murder weapon, I would say that the prosecution choose one, considering that I would say that this is cumulative, and I would also ask that specifically Exhibit 5 not be included, as it is more prejudicial than probative, as the jury doesn't need to see all that blood, since there's a perfectly good other picture of the knife, and this doesn't show anything except the gore. And additionally, I would ask about the relevance of the knife drawer.
Overruled as to both relevance and probative. They will be entered.
I also objected based on that it's cumulative, because there's two pictures of the knife.
Thank you. That's overruled as well.
Yes, Your Honor. Now, referencing these exhibits and given your analysis of the other knives present in the house, did the knife come from the victim's kitchen?
Yes, it is fairly clear that it did. As we can see, Mr. Brachman had a number of knives, but we can see that the knife used for the murder would have fit quite well into the knife block, as well as the fact that every knife in that block is present except for the chef's knife.
Now, referencing Exhibit 4, which has already been entered into evidence, can you please explain to the jury what important analysis you gathered from this evidence?
Yes, of course. So if we look at the actual angle of the knife wound, we can see that it is horizontal. It's a little bit off of being parallel to the victim's shoulders. So that does support my personal scientific theory that the victim and perpetrator were engaged in a fight with one another. They were eventually facing one another and wrestling. And the perpetrator, able to hold the knife, would be holding it at a horizontal angle. That would be the most comfortable and intuitive. And he was able to kind of use his elbow to swing into the victim's back, also giving him enough force to get through the scapula.
Now, is your conclusions in this case similar to the conclusions of that of the defense?
They are not. I am aware of Mr. Blake Van Owen of the defense, who had claimed that the perpetrator managed to break into the victim's house without the victim noticing and eventually stabbed the victim, similar to, I believe he compared it to the movie Psycho. But we obviously see that this is a horizontal knife wound, and Mr. Van Owen's theory about the actual scenario of the stabbing would have created a vertical knife wound.
So based on this knife wound analysis, does Mr. Van Owen's theory of the crime scene make any sense?
It simply doesn't add up. The idea that the victim would not notice somebody attempting to enter his front door and eventually entering his back door is incredibly unlikely, as well as the fact that the angle proposed would not align with what we actually see in the evidence.
Now, given the evidence and analysis that you've applied, in your expert opinion, what did the perpetrator intend to kill Mr. Brachman upon initially entering the home?
I would say that's a definite no. We see from the ring security videos that the perpetrator enters unarmed, and anyone intending to commit a murder would obviously bring the weapon with them. And we find that the knife came from Mr. Brachman's own home, as well as the fact that it seems that a struggle ensued.
And given, again, in your expert opinion, given the evidence and analysis that you applied to this case, who was the perpetrator in this case?
From what I have observed of the other evidence, considering the different witnesses I have heard from, this very clearly points to Avery Becker.
Thank you, Your Honor. No further questions at this time.
Any cross-examination?
Yes, Your Honor. Good afternoon, Ms. Cusack. In your investigation, is it correct that you reviewed all the photos and videos pertaining to this case?
Yes, I consider it very important to know all of the evidence.
You also mentioned that among these photos that you reviewed were photos depicting blood droplets and blood spatters. Is that true?
Yes.
And the reason that the court cannot examine these photographs today is because they were lost. Is that also true?
Yes, somewhat in... I'm sorry.
In your investigation, would you also have reviewed the photos of the scuff marks? Is that correct?
Yes, I did review those, and those pertain to my theory of the fight.
Right, and is it true that your theory is that these scuff marks indicate a struggle?
Yes.
Isn't it also possible, however, that these scuff marks being right next to the victim's back door could have been caused by any number of things, like yard work? Couldn't that be correct?
Well, I wouldn't believe one does yard work inside of their house, just inside the doorway. But, excuse me, sorry, you cut out.
No problem. It's a yes or no question. Is it true that any number of things could have caused those scuff marks?
Yes.
Okay, and moving on. So next in your theory, is it correct that you believe the victim grabbed a knife from the knife block to defend himself?
Yes.
And according to your theory, it's true that this same knife would have then been used to stab the victim in the scapula after a brief struggle. Is that correct?
That is correct.
But isn't it also true that the knife recovered from the right next to the body, the one covered in blood, was a completely different brand of knife from the knives in the block?
Yes, but it's not uncommon for people to replace the given knives with better ones.
Nevertheless, it is true that this was a different brand of knife. Yes or no?
Yes.
So you then believe that the victim and intruder engaged in a struggle?
Yes.
And that during this struggle, the intruder gained control of the knife and stabbed the victim in the scapula?
Yes, that is what my evidence points to.
So then is it true that what you described, is that the intruder would have reached all the way around the victim who's a grown man, to stab him in the shoulder? Is that correct?
Yes, that is correct.
And give me a second, I'm just trying to do the math here. To do what you're describing, then, isn't it true that the intruder would have had to be pretty tall and extremely strong, more tall than any human being?
No, not particularly. And I mean, given that, as I described in my report, that it would have been a sort of bear hug, the two would have been in extremely close contact, as well as the point that being able to hinge the arm as the perpetrator did would give an incredible amount of leverage to drive the knife into the victim's body.
I wasn't talking about the leverage, I was talking about the height of the intruder. And isn't it extremely unlikely that a teenager would be that tall, tall enough to reach all the way around a grown man and stab him in the scapula? It seems unlikely to me.
Well, the fact the teenager or the person who committed this crime would not have to be taller than the victim. Again, given the position in which the stabbing occurred, it would be very easy to simply raise the arm to a higher level, which is also supported by the angle of the knife through the shoulder blade to the heart.
Let's move on. Let's talk about the ring videos. Is it correct that the intruder is wearing a mask in the videos?
Yes.
And isn't it also true that the intruder is wearing gloves and a hoodie?
Yes.
So would it then be correct that it would be basically impossible to tell a person's race, gender, or any other defining characteristics from that video? Is that true?
That is true, but it is not our only evidence.
And isn't it also true that there was no physical concrete evidence to actually link anybody, including the defendant, to the scene of the crime? Is that correct?
That is true.
And now, according to your theory, it is also true that the victim would have been alerted to the presence of the intruder via the alerts from the Ring app?
Yes, either by the Ring app or simply hearing somebody at his door.
We're not talking about the door. We're talking specifically about the alerts from the Ring app. In your investigation, isn't it also true that you failed to actually get records to confirm the alerts? Is that correct?
I personally do not investigate digital systems. That is not my job. But I believe those records were obtained by Detective Markowitz.
Right, but you didn't review these records in your investigation. So isn't it true that you cannot possibly be certain that the victim received alerts from the Ring app? Is that correct?
I mean, one can never be entirely certain of anything, but I suppose that would be a yes.
Okay, well, in your testimony, you said that you wished you had more evidence. Is that correct?
I mean, I always wish I could have more evidence. I believe any person in the scientific field does.
Ms. Cusack, do you know the definition of reasonable doubt?
I'm not a legal professional, but I am familiar.
Objection, Your Honor. This question is out of the scope of the witness. As the witness just stated, they are not a legal expert. They are simply here to testify on the scientific basis and the conclusions that they came to based on science. They do not need to know a definition like this.
Sustained. It's outside of the witness's expertise.
So, if there is not ample evidence in this case, then how can you specifically, as an expert witness, if there's not ample evidence, how can you possibly come to a conclusion beyond a reasonable doubt, which is the prosecution's burden?
Objection, Your Honor. Again, the opposing counsel is using reasonable doubt, which is out of the scope of the witness. This has already been ruled on.
Your Honor, I specifically asked that isn't it true that in their as their expertise, they wouldn't be able to come to a concrete conclusion in the field of their expertise as to what happened that day based on how you said that there was lack of evidence?
I've sustained and continue to sustain beyond a reasonable doubt that that's outside of our expertise. You can break down the questions as you're asking them about any weakness you find in your investigation, but beyond a reasonable doubt is beyond our expertise.
Sorry, I didn't hear very much of what you said, Your Honor. I think there must be some sort of interference.
I also did not hear a lot of it, Your Honor. Can you repeat it? I think we're just having a little bit of trouble hearing you, Your Honor.
I was just making sure my sound was where I thought it was. Can you hear me now?
Yes, clearly.
but that's okay. No further questions, Your Honor.
All right. All I did was sustain the objection again and sustained it and said that you're allowed to ask questions based on what you think the weakness of the investigation is, just not about beyond a reasonable doubt. That's beyond her expertise.
Thank you, Your Honor.
Prosecution's next witness.
Your Honor, may I have a brief redirect?
I apologize, you may.
Thank you, Your Honor. And can I also request a brief time check? Thank you. Now, Ms. Cusack, did the lost blood splatter pictures have any major effect on your analysis in the case?
No, those were lost fairly late into the investigation, as well as the fact that any blood from the crime came from the victim himself.
And based on the violent crime that took place, what is the most logical explanation for the scuff marks found at the doorway?
Well, especially concerning the scuff marks, those were incredibly dark, more similar to something you might see in, say, a basketball court where people are moving very quickly and very energetically. Obviously, in this case, that would not simply be regular movement in and out of a house. As well as the fact that there was a broken plate on the floor, I believe any reasonable person does not leave broken ceramics on their floor.
Thank you, Your Honor. No further questions.
Your next witness.
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand. May I proceed, Your Honor?
You may proceed.
Good afternoon, Ms. Cifuentes. Can you please state your name and spell your last name for the record?
Yes, my name is Alex Cifuentes, spelled Sifuentes.
And jumping right in, Ms. Cifuentes, where did you attend high school?
I went to Colorado High School, and everyone calls it CHS.
And how do you know the victim in this case, Mackenzie Brockman?
He coached the mock trial team that I was a part of last year.
And how do you know the defendant in this case, Mr. Avery Becker?
Avery and I used to be really good friends, and we're both on the mock trial team coached by Mr. Brockman. In fact, it was Avery who introduced me to mock trial in the first place.
And what is your opinion of the defendant?
Although we were friends, I did not appreciate the way Avery treated our teammates or Mr. Brockman.
Why did you not like the way that the defendant treated your teammates and Mr. Brockman?
Mr. Brockman was always pushing Avery to do better because he could see the natural talent in him, but Avery always refused and played the victim instead of working hard.
Now, could you please briefly describe the incident in which Mr. Becker was demoted from the A team to the B team on mock trial?
Well, after Avery came to practice late for the umpteenth time and regionals were right around the corner, Mr. Brockman demoted Avery to the B team. And after that, Avery manipulated Taylor into quitting for him.
And was this the only incident in which the defendant and Mr. Brockman butted heads?
No.
Can you please describe the events that led up to the second incident in which they butted heads?
Well, at the very next practice, Mr. Brockman tried to explain to Avery that there was a big difference between good acting and being a good lawyer. And he told Avery that to be a successful lawyer, he would have to prepare more.
And how did the defendant respond to these comments?
Avery was super angry. And as he was leaving campus, he wrote across Mr. Brockman's Porsche, "Worst Attorney Award" in all caps with a permanent marker.
And what happened to the defendant after he vandalized Mr. Brockman's car?
Well, Mr. Brockman kicked Avery off the team permanently. But if you ask me, he should have pressed criminal charges and put all of this to rest.
Now, at this time, let the record reflect that the trial technician is going to share Exhibit 14. Now, Ms. Cifuentes, do you recognize Exhibit 14?
Yes.
What is Exhibit 14?
Those are the text messages I received from Avery.
And how do you know what Exhibit 14 is?
I was the one who received them, and it's my phone.
Your Honor, at this time, I move to enter Exhibit 14 into evidence.
Defense's position.
Yes, Your Honor, I have a few objections. First, to authenticity under Rule 901, the police had no way of authenticating these texts as it was a screenshot sent to the police, and also hearsay as it is evidence offered for truth of the state or truth of the matter asserted.
Response?
Your Honor, to the first objection based on the authenticity of this exhibit, I believe the witness, Ms. Fuentes, has testified to its authenticity, and seeing as the witness is sworn in, I believe that we can take her word for the authenticity. And to the second objection of hearsay, seeing this is as a statement by the party opponent, it is an exception to hearsay.
Objections overruled. You may proceed.
Now, Ms. Fuentes, could you please follow along while I read some of these text messages? Beginning on the first few lines. From Avery Becker. Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. Then you, Ms. Fuentes, responded, what are you going to do to his house? Mr. Becker then responded, I'm going to wait until he's at work, then break in and trash it. Did I read that correctly?
Yes.
Now, Ms. Fuentes, I have one final question. Was Mr. Becker as good in his witness roles as he was in his various attorney roles on mock trial?
Avery was a fantastic actor and an amazing witness. He has this way of making you believe anything that he says.
No further questions, Your Honor.
Any cross-examination?
Yes, Your Honor. May I proceed?
Please proceed.
Good afternoon, Mr. Fuentes.
Good afternoon.
At the night of March 5th at the Fry Shack, you touched Avery's phone, isn't that correct?
Yeah, Avery let me play a game on his phone, but he was there with me the whole time.
And the next day, Avery's phone went missing, and it's still missing, isn't that correct?
Yeah, I guess Avery should just keep better track of his belongings.
And you sent a screenshot of your phone to the police for the investigation rather than bringing it in, isn't that correct?
I did. The investigator said that was enough.
May I please bring your attention to Exhibit 14? Can I please see Exhibit 14, if possible?
It can be brought up.
When you receive a text, you receive a time and date stamp. Is that correct?
Yes.
And do you see a time and date stamp here?
I see the time at the top left corner.
That's the time of the phone at the current time, isn't that right? Not the time the text was sent?
I mean, I believe so. I just sent the screenshots like the detective asked.
And you coincidentally replaced your phone right after the murder of Mr. Brockman?
It was hardly coincidental. My battery was having trouble for a long time, and I could barely use it anymore. And you know how I can be with teenagers can be with their phones.
But you did replace it, even though you knew it contained crucial evidence that could put the person you call your best friend in prison. Isn't that right?
Well, I was sure that the detective said that the screenshots were enough, and after that, I thought my role was done. So yes, when you're asking, I did trade it in, yes, but that was completely separate from the trial.
Moving forward, you were jealous of Avery's success as a lawyer on the mock trial team, weren't you?
You could definitely say that Avery's lack of work ethic irked me when he receives these awards.
You said it felt like a slap to the face every time he succeeded, didn't you?
I mean, nobody likes it when someone like doesn't study and aces a test while students are struggling to pass, but it doesn't mean that I had it out for him in any way.
But you spent hours working on your preparations for mock trial, isn't that right?
Oh, I did, and I take pride in my work. And yeah, I am proud of the time that I've put in.
Yeah, Avery got all the roles in each tournament, the best roles.
Well, we were both on A team, and we were very equal lawyers. Yeah, Avery.
I'm sorry, Mr. Fuentes, it's a yes or no question. He got all the best roles for each tournament.
Well, what I'm saying is there are lots of good roles.
He got all the awards.
Could you repeat that?
He got all the awards. He won the Best Attorney Award, isn't that right?
Yes, that's correct.
And were you at all mad that Mr. Brockman constantly picked Avery over you?
Well, sure perhaps I was irked, but these accusations here in court are completely independent of my feelings towards Avery. I want to see him in jail no more than I wanted to find out our coach was murdered.
Moving forward, you knew Blair Rollins, didn't you?
Yeah, Blair and I went to school together.
And can you tell me who the lawyer was on the case that sent Blair's father to prison?
Objection, Your Honor, lack of personal knowledge. This witness would not know this information.
May I respond, Your Honor?
Yes.
This court case was a very important court case that sent this student's father to prison. And the lawyer on this case was the mock trial coach, Mr. Brockman. And as Mr. Fuentes and Mr. Brockman had a pretty close relationship, and it would have been known to everybody that the student's father went to prison, everybody would know that this lawyer was on this case.
I believe she's asked the foundational question and it can be answered. So she asked first, are you aware he went to prison? And now I think is asking, were you aware that her father represented him?
Mr. Fuentes, will you please answer my question?
Can you repeat it, please?
Yes. Who was the lawyer that sent Blair Rollins' father to prison?
That was Coach Brachman.
And have you seen Blair since the murder of Mr. Brachman?
Well, I personally haven't, but I haven't seen it. I never saw him very often in the first place.
No further questions.
Any redirect?
Yes, Your Honor. Now, Mr. Fuentes, what was your relationship like with the defendant?
Avery and I were friends. Our roles in mock trial pushed each other to be better. And although Avery received more awards than me, that has nothing to do with the trial here today. All that I'm here for is to tell the truth. And now referencing Exhibit 14, why did you send screenshots of the exhibit instead of showing the detective these screenshots in person? Because the detective said that that was enough. No further questions, Your Honor.
Anything based off the redirect?
One thing. So there wasn't a timestamp or a date stamp on the phone text that would authenticize these texts?
No, there was not.
No further questions.
Prosecution, do you have any further witnesses?
No, Your Honor, the prosecution rests.
Defense, do you have any witnesses?
Yes, Your Honor, we would like to call Professor Van Owens to the stand.
You may proceed.
My apologies, Your Honor. I was just having a hard time figuring out my camera. Professor Van Owen, could you please state your first name and spell your last name for the court?
Blake Van Owen, Vanowen.
And can you please tell the court what and where you teach?
Yes, of course. I teach a course on police practices and social justice at CU Denver.
And what credentials do you have that allowed you to become a professor?
I obtained my master's from Ashford University's online program.
Before you obtained your master's, what other hands-on experience did you have in crime scene investigation?
Well, I began my career working in the Aurora Police Department. However, after an incident with a young woman of color, I ended up leaving the department. Though I was cleared of all my wrongdoings, I never quite managed to clear my own conscience, and I had to leave. And ever since then, I've been working as a private investigator in order to fight some of the malpractices of the police department.
Have you ever testified as an expert witness before?
Yes, I have. I've testified as in crime scene reconstruction 8 times, cell tower analysis 5 times, as well as general police practices 12 times, and consulted on over 100 cases.
Can you walk the court through a general methodology regarding how you usually perform cell tower analysis?
Yes, though cell tower analysis may seem like an exact science, that is not in any way the case. In no way does cell tower analysis compare to GPS. It normally only gives a basic location and a large area in which a cell phone could connect to a tower. For example, you could be standing right next to a tower, and the phone may connect to another cell tower over a mile away if it got better connection from that other tower.
At this time, the defense moves to enter Professor Van Owen as an expert witness in crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Prosecution, your position?
No objections to the tendering of this expert, Your Honor.
Admitted, it be admitted for the expertise that, as stated.
Professor Van Owen, given your time with the Aurora Police Department and as a private investigator, how would you describe your level of familiarity with crime scene analysis?
Yes, I'd say that my experience as both a police officer and a private investigator made me incredibly familiar with crime scene reconstruction.
And did you do a formal report on this investigation?
Yes, I did.
Could the trial technician please pull up what has been marked for identification purposes as Exhibit 20 to show to the witness? Do you recognize this exhibit, Professor Van Owen?
Yes, I do. This is my expert report on the case.
And do you recall writing this report during your investigation?
I do.
Is this a fair and accurate representation of the report that you wrote during that time?
Yes, it is.
Your Honor, I move for the admission of Exhibit 20.
And prosecution, your position?
No objection to this evidence, Your Honor.
It shall be admitted.
Permission for this to be published to the jury, as it is being screen presented right now, but it has not been published to the jury yet.
It will be published.
Professor Van Owen, could you please explain how the structure of cell tower coverage relates to the location of a person?
These cell towers normally operate in 320-degree areas and a 6-mile radius that each correspond with a different antenna on the cell tower. So all that if a phone were to connect to the cell tower, all it would say was that that phone was within a 6-mile radius in that 120-degree area of the cell tower at that time.
Could the trial technician please scroll down to page 4 of the expert report of Professor Van Owen? Thank you. Is the cell tower coverage, is this effective?
No, it's not in any way. It gives a broad area at where the phone could have been when it connected to the cell tower.
Sorry, Mr. Vanna. And were you able to review the records of the cell tower communications?
No, I wasn't able to do that. The prosecution didn't bother to get the records of communications with the cell tower.
Let's move on. While you were compiling your report on this investigation, did you take any photographs?
I did, yeah.
Could the trial technician please display what has been marked for identification purposes as Exhibit 21 for the purpose of showing the witness? Professor Van Owen, do you recognize this exhibit?
I do.
How do you recognize this exhibit?
That's my hand in the picture, and I was also the one that photographed it.
Does this accurately reflect the picture that you took yourself?
It does.
Your Honor, I move for the admission of Exhibit 21.
In your position, prosecution,
No objection to this evidence, Your Honor.
it shall be admitted.
Professor Van Owen, why did you take this photograph?
Well, as you can see, the indent in the knife is normally where someone would place their fingers, whether the knife was in a downward position or it was over their head.
Please walk us through how you think that this would relate to the position of the intruder and the victim.
I believe that the most likely position of the victim was most likely in a seated position, while the victim snuck up behind and stabbed him in the back from an overhead position.
And would you say that your hand position depicted in this photograph is a common way to hold a knife?
Yes, that's the most common way that you'd hold this type of knife.
In reviewing the prosecution's evidence, did you get a chance to analyze the ring videos?
I did, yeah.
Could the trial technician please display Exhibit 11?
Apologies, would you like me to play the video for the witness?
Yes, please, thank you. Now, Professor Van Owen, is this one of the videos, the ring videos that you reviewed during your investigation?
Yes, this is.
And how do you know that it is one of the ring videos?
Well, I reviewed the ring videos during my report.
Is this video a fair and accurate representation of the video you reviewed during your investigation?
It is.
Your Honor, I ask for permission to enter Exhibit 11.
Prosecution, your position.
No objections to this evidence, Your Honor.
It will be admitted.
Your Honor, I ask for permission to publish this exhibit to the jury.
Permission granted.
In your expert opinion, Professor Van Owen, what can you determine about the intruder from these videos?
Well, as you can see, not only is the intruder masked, but also gloved. So essentially, the only information that we get from this video is the height and build of the intruder.
Did you know that the prosecution is using these videos to connect Avery Becker to the crime?
Yes, which if you can connect, or if you can prosecute someone based solely on their stature, then there's many possible other teenagers with the exact same build. So that doesn't necessarily point to Avery Becker in the slightest.
Did you also review the photographs of the scuff marks?
Yes.
As an investigator, would you consider these scuff marks worthy of note?
No, I wouldn't. You can't carbon date scuff marks. These could have happened at any time. And I'm pretty sure most people have scuff marks in their homes.
Are you aware that the prosecution considers these scuff marks indicative of a struggle?
I was aware of that, which is simply ridiculous.
Your Honor, could I please get a brief time check?
Yes.
I would also ask, oh, thank you. Let's continue. During your investigation, did you get the chance to look into any other students at the school?
Yes, I did.
Which student stood out to you in particular?
A student by the name of Blair Rollins.
And why did Blair Rollins strike you as familiar?
Well, Blair Rollins was both a similar height and stature to Avery Becker and the intruder that we saw in the video.
And how did you know that he was the same height and build?
Well, I knew that because both Avery Becker and Blair Rollins were the same size.
In your investigation, did you also look into the case of Blair Rollins' father?
I did, yes, I reviewed the case.
And what happened in this case?
Well, you see, Brachman was the defense attorney in Blair Rollins' father's case. Eventually, Jonathan Rollins, the father of Blair Rollins, would be prosecuted in that case and even threatens to commit harm upon on Brachman.
In your expert opinion as a crime scene investigator, would you say that failing to save one's father from prison is a powerful motive?
Yes, and not only is it a powerful motive, it's much more powerful than getting kicked off the mock trial team.
No further questions, Your Honor.
Any cross-examination?
Yes, Your Honor.
Proceed.
Thank you. Good afternoon, Mr. Van Owen. Now, you used to work for the Aurora PD, correct?
That's correct.
But you left and now work as a private investigator,
Yes.
where you are paid much, much more than your previous job.
Yes, I'm making more as a private investigator than I was as a police officer.
In fact, you've charged over $7,000 for the current case today.
Yes, I typically charge around $6,000 to $10,000, and you got to pay your bills somehow, right?
And you expect that you will be paid at least $1,000 more after your testimony here today in court.
That's what I'm anticipating I'll bill, yes.
Now, moving on, you do not like Detective Markowitz very much, do you?
Well, I wouldn't say I don't like him. We just have had our run-ins in the past.
But you go as far as letting it affect your professionalism and call him Defective Markowitz.
Well, that was just me joshing around.
That was you joshing around in a signed affidavit for the court?
I did not believe that in any way was that hold weight to my affidavit or an important fact.
But you do say that in your affidavit and let it affect your professionalism.
Not necessarily perfect my professionalism, but I did refer to him as Defective Markowitz.
Now, a significant portion of your affidavit seems to be you refuting Detective Markowitz's claims.
Well, yes, as an expert on the defense side of the trial, I believe that is largely my job.
And you claim that there was another potential suspect, Blair Rollins, who had the motive and opportunity to harm Coach Brachman.
That's who I believe the most likely suspect is in this case.
But the court was not able to interview him or subpoena him to testify in court today.
No, the prosecution never even looked to do that, and Blair Rollins, I believe, is most likely out of the state at this point after he disappeared after graduation.
But we are not able to verify your claims or even any of the allegations you're tendering against this person.
Well, yes, and as I stated earlier, Blair Rollins had a clear motive. He was also the same size.
Well, I'm not asking about that. I'm asking that the court was not able to even get a hold of Blair Rollins to verify any allegations.
Yes, exactly, because he left the state, which seems pretty fishy to me.
And you were also unable to access the cell phone records that would have pointed you towards Blair Rollins?
Nor did the prosecution.
Now, moving to some of the other claims that you have against the prosecution, you claim that Coach Brachman was sitting at his kitchen table when he got stabbed.
That's what I believe the likely position of the victim to be.
So let me walk through what that means. That means that the intruder tried to enter the home through the front door, triggering the Ring security system.
Not necessarily. Yes. The victim, Brachman, didn't necessarily even have alerts on his phone, so that's very likely.
But it did trigger the security system.
Yes, but that doesn't necessarily mean the victim would have known that someone was at his front door at that point.
But after this triggered the security system and they failed the attempt to break in through the front door, the perpetrator entered through the victim's back door.
That's correct.
Again, triggering the Ring security system.
Which did not necessarily notify Brachman.
And they went from the back door into the kitchen.
Yes.
In an unfamiliar house that they had never even been in.
Yes, they had most likely never been in the house, but who am I to say?
And they finally, after all of this, snuck up on the victim and stabbed him in the back.
I believe this a much more likely scenario than a teenager out wrestling a grown man.
So during all of this commotion, Mr. Brachman simply just stayed seated with his back to the door?
Well, I'm sure he was doing something and he was distracted.
Was there any evidence around the kitchen table that you could acquire, like headphones or blaring music, that would have indicated such a thing?
No, that doesn't necessarily mean that he was just sitting there. He was most likely focusing on something else or in his head.
Now, referencing the second page, or will the trial technician please put up Exhibit 20 and scroll down? Now, referencing this second page, you state that the knife was held in the way shown in the picture.
That would have been the most comfortable position, yes.
And this knife is being held point first with the blade vertical.
That's correct.
But it was still used in a normal stabbing motion similar to the movie Psycho.
Yes, that's how I believe I described it.
And you also state that this is the most common way to hold such a knife.
Yes, and the most comfortable.
And you claim that this way of holding the knife in a stabbing motion would have resulted in the wound matching the victim's.
That is true.
Now, will the trial technician please put up Exhibit 4? Is the trial technician okay? Can you please put up Exhibit 4? Thank you. Now, looking just plainly at this exhibit, anyone can see that this knife wound is horizontal, correct?
Yes, it's somewhat of an L shape.
But it is mostly the width of the knife, which is noted in the autopsy, is horizontal.
That's correct. And my expert opinion and my
I'm not asking for your expert opinion right now, Mr. Musara. I'm just simply asking you, is the knife wound horizontal?
Mr. Van Owen. Professor Van Owen.
Oh, sorry. Mr. Van Owen. Now, this horizontal orientation does not match with the vertical knife positioning you just claimed was used.
No, but I stated in my report that the victim most likely took the knife out of his back, and during the exit of the knife, it was most likely when that mark on his back was created.
So you're claiming that while the victim pulled the knife out of his own shoulder, he pulled it closer into his shoulder to make a horizontal mark, not outward?
I think reaching behind you and pulling a knife out is probably not an easy task, and I'm sure that he struggled to do it, and while it was happening, he most likely made the injury worse.
So in that struggle, he grabbed the knife with his right hand and pulled it closer into his body as opposed to pulling it out?
Well, again, if you're reaching around your back, it's a pretty difficult motion, especially while you're injured, to pull the knife directly out.
But even if the assailant had turned the knife to make a horizontal cut, wouldn't that have been an awkward position?
Yes, it would have been awkward.
And it wouldn't have allowed the perpetrator to exert the traditional force of a stabbing.
Sorry, could you repeat that?
This position would make it more difficult to exert the traditional force in a normal stabbing.
I believe that he could have generated more force in this scenario than if he were to stab them in the back while he was in front of him.
Even in a more comfortable position where the victim was, or the perpetrator was simply just shoving the knife into the body with a normal horizontal angle?
I believe that if the suspect snuck up behind the victim, pulled the knife over his head, and then moved the knife downwards, that would be plenty enough force to create that type of cut.
Even if he wasn't able to fully pull back the knife as his shoulder was in the way to make it a horizontal orientation?
Yes, I think that most likely when he pulled the knife out, again, he was struggling, reaching around your back and trying to pull something out. It's just not a natural motion for the human body. And I believe while he tried to do that, he most likely ended up causing that orientation.
Now, according to the coroner's report, when the knife nicked the aorta, there was heavy internal bleeding, correct?
That's correct.
which means that the victim died very, very quickly.
Yes, the bleeding most likely intensified when the victim pulled the knife out.
But what you're saying is that the victim got stabbed, pulled the knife out of his own shoulder, stood up, and then walked all the way to his front door.
I believe that he stood up and walked towards the front door and then pulled out the knife. And that's where the blood driplets were coming from as he was pulling out the knife.
But all still while having massive internal bleeding.
Yes, and that doesn't necessarily mean that he wasn't capable of walking.
No further questions at this time, Your Honor.
Any redirect?
Yes, Your Honor, I just have a couple of quick questions. Professor Van Owen, what is your job as a defense expert and as someone who investigates police investigation tactics?
My job is to not only defend the witness, but also to prove the accusations of the prosecution defective and wrong.
Yeah, exactly. So is it your responsibility to prove the guilt of another suspect?
No, it is not. That is the role of the prosecution.
And is it your responsibility to gather appropriate evidence for this case?
My job is to review the evidence that the prosecution collects.
That's all, Your Honor. Thank you.
Any questions based off a redirect?
No, Your Honor.
Does defense have another witness?
Yes, the defense calls to the stand Mr. Taylor Perkins.
Please proceed.
Good afternoon, Mr. Perkins.
Good afternoon.
Please state your name and spell your last for the court.
Taylor Perkins, Perkins.
So, Mr. Perkins, can you tell me a bit about yourself?
Well, I went to CHS high school, and I was on the mock trial team there.
And what is your relationship with the defendant, Avery Becker?
Avery Becker's a good friend of mine.
And how do you know the victim, Mr. Brachman?
Mr. Brockman was the mock trial coach.
You mentioned you were on the mock trial team at school. Why are you not on it anymore?
I was on the mock trial team, and then there was a little incident where Avery got demoted because of his lack of preparedness. So I stepped down. I also really wasn't a fan of mock trial, and I was also a lawyer. So it just wasn't really my year to be on the team.
What was Avery like on the mock trial team?
Avery was the best on the team. He was usually unprepared, but that didn't matter at all. He was still the best person on the team and most important.
What influence did Avery have on the success of the mock trial team in tournaments?
His presence was detrimental to the team. Usually if he wasn't there.
Excuse me, can you repeat that?
My objection was relevance, Your Honor.
Response?
Yes, Your Honor. Well, this student just was on the mock trial team, and by stepping down, it shows that he wanted the team to still succeed, even if he didn't want to be on it.
It's relevant. Proceed. Overruled.
Yes, Your Honor.
Could you repeat the question?
Yes, Your Honor. Yes. What was Avery's relationship like with Mr. Brachman?
Avery and Mr. Brachman had, I guess, a rocky relationship. I thought it was kind of funny, the feud. Just Coach Brachman would get annoyed at Avery because he never came prepared, and then he still performed. He still outperformed everyone on the team. So I think that just annoyed Coach Brachman a little bit.
Moving forward, can you tell me what you did after school the evening of March 5th?
After school on March 5th, we went, so Avery came over to my house after trying to apologize to Mr. Brachman, and then we went to Fry Shack.
And can you tell me about what happened at the Fry Shack?
At Fry Shack, we were met with the entirety of the mock trial team there, and basically everyone was trying to tell Avery about how unfair it was that he got kicked off the team, And even Alex Affrontus was trying to tell him that, but seemed pretty insincere. So Avery got up and went to the bathroom to cool down.
And did anything happen while Avery was in the bathroom?
Well, I noticed that he left his phone on the table.
And did anybody touch the phone while he was in the bathroom or before that?
I think Alex Affrontus was playing games on the phone.
And have you seen Avery's phone since that night?
No, that is the last time I saw the phone.
Has he been able to recover this phone?
No.
What did you do after you left the fry shack?
After we left the fry shack, we went to the mall and walked around a little bit, talked. We were in a pretty good discussion about like what happened on the team, and we looked in some stores.
So what happened the next morning, March 6th, the day of the murder?
The next morning, both Avery and I had our first period off. And when that happens, Avery usually comes and picks me up and takes me to school. And I texted him a bunch to see if he was coming to pick me up, and he never answered, but he did pick me up. And when he picked me up, I mentioned that. And then he realized then that his phone was missing.
So what did you do for that entire day?
Could you repeat the question? Sorry.
So what did you do for the entirety of the day?
Oh, after that, we realized that we really had no reason to go to school. We already took our important quiz earlier in the week, and the rest of our classes were kind of just non-important. So we went and we looked for the phone the rest of the day.
Can you tell me where you went?
So first, we just kind of retraced our steps. We went to the mall, and then we went to Fry Shack, and then we looked some more, and then went back to Fry Shack.
And just to clarify, you were with Avery the entire day?
Yeah, the entire day, from when he picked me up till late that night.
Can you tell me, did you go anywhere near Mr. Brockman's house or anywhere near where he lived?
No.
Can you tell me a bit about Alex Affrontus?
Well, most of what I know about Alex Affrontus is from our experience on the team. And so it'd been basically, I know that him and Avery butted heads during practice sometimes.
And can you tell me what do you know also about Blair Rollins?
I do, yes.
Can you tell me a bit about him?
I know him from school. He was a strange character, kind of creepy, but that's pretty much it.
Can you tell me about the relationship between Blair Rollins and Mr. Brockman?
Oh, this is, so basically Blair Rollins had a dad who got sent to prison because of supposedly Coach Brachman's not so good lawyer work.
And can you tell me anything about Rollins and his whereabouts since the murder of Mr. Brachman?
I have no idea where he is.
No further questions.
Any cross-examination?
Yes, Your Honor. Good afternoon, Mr. Perkins.
Good afternoon.
Now, you weren't a fan of mock trial, correct?
I wasn't the biggest fan of it. I didn't really mind it, but Avery was there and we were friends. So, I kind of just went.
And you only did mock trial because Avery did it?
Yeah, that was a big part of it.
And now regarding Mackenzie Brachman, you thought Coach Brachman was a mediocre coach and lawyer, correct?
Yeah, I did.
And you mentioned that Avery, Becker, and the coach had a feud, right?
Yeah, there was a little feud there. It's pretty funny.
Yes, you said this feud was funny on your direct.
It was, yeah.
Avery Becker played pranks as part of this feud?
Well, I think the funny part was just like how annoyed Coach Brachman would get about Avery showing up like.
Thank you, Mr. Perkins. My question was, Avery Becker did play pranks on this feud, yes or no?
Oh yeah, that was part of the feud.
Now let's talk about the incident that occurred after practice for the regional tournament. Coach Brachman got very heated because of Becker's unpreparedness, right?
Yeah, he'd get annoyed.
So much so that Brachman demoted Avery Becker to the B team.
Yeah, I think Avery kind of pushed him to his breaking point there.
And now again, after the regional mock trial tournament, there was an argument between the two.
Yeah.
And after this, Avery got so upset that they wrote "worst attorney" on Brachman's car.
Well, I understand
Objection,
that,
Your Honor. According to Rule 602, lack of personal knowledge, Mr. Perkins was not there at the incident, so he would have no way of actually knowing what happened.
Response? Your
Honor, as the relationship between the defendant and Mr. Perkins has been clearly established as they were best friends, and Mr. Perkins was shown to be at the regional tournament, he would know, or he would have the knowledge to testify to this question.
Overruled.
Yes, Your Honor. Now, would you like me to repeat the question, Mr. Perkins?
Yes, please.
After the argument at the regional competition, Avery got so upset that they wrote Worst Attorney Award on Brachman's car.
Yeah, so I guess what I heard from the argument was pretty rude, so I kind of understand that. But Avery regretted it completely.
Thank you, Mr. Perkins. The writing even ruined the paint on the Porsche.
Yeah, I guess Avery thought the marker was a dry erase marker, and he even told me that after he did it, without knowing that it actually ruined the Porsche. But in the end, it did, and Avery felt.
Thank you, Mr. Perkins. Coach Brachman then kicked Avery off the team, correct?
Yeah, after that, he kicked him off the team.
And you said this wasn't fair.
Not necessarily, because it was a complete mistake, and you could tell by Avery's sincerity about it.
And now let's talk about your relationship with Avery. You consider Avery a friend, right?
Yep.
You even stepped down from the A team for Avery?
Well, that was one of the reasons. Also, it just wasn't my year. Like you said, I don't like mock trial. I was a lawyer, and it was kind of just pointless for me to be there.
Now, after you stepped down, you said that Avery tried everything to get back on the team after being demoted.
Yeah, he reached out to everyone on the team, and then I think even Alex Cifuentes, and then he even went to go apologize to Mr. Brockman unsuccessfully.
Yeah, correct. Coach Brachman refused to let Becker back on the team even.
Yeah, I think that's what happened.
And then on the day of March 6th, the day of the murder, you were with Avery the entire time, correct?
Yep.
And you didn't see your teammates at the Fry Shack until later that evening?
Yes.
Now, no one who was at the Fry Shack can vouch for your whereabouts for the entirety of the day, correct?
No, but mine and Avery's stories completely match.
Now, no one at the mall can vouch for your whereabouts for the entire day either.
I don't know anyone at the mall, so I mean, if I did, they probably could, but no, I guess.
Mr. Perkins, no one else was with you and the defendant for the entirety of the day, correct?
No, just me and Avery.
Thank you. No further questions.
Any redirect?
Yes, Your Honor. Just to clarify, you were with Avery the entirety of the day on March 6th?
Yep, we went to the mall, Fry Shack. We were just looking for his phone the entire day.
And you two didn't go near the house of Mr. Brockman at any point during that day?
No, nowhere near the house.
And you would tell the truth because you're sworn in, even if that meant turning against your friend?
Oh, I'd never lie, like, to endanger myself for Avery.
No further questions. Thank you.
Anything based off the questions that were asked?
No, Your Honor.
And any further witnesses from the defense?
Yes, Your Honor. The defense would like to call our final witness, Avery Becker, to the stand.
Proceed.
Proceed. Good evening, Mr. Becker. Can you please state your full name and spell your last for the court?
Yeah, I'm Avery Becker, Becker.
Mr. Becker, where did you attend school?
I was a senior at CHS, or Colorado High School, last year.
And did you participate in any activities at Colorado High School?
Yeah, I did. I was on the mock trial team for all 4 years.
And how well did you perform in mock trial?
You know, mock trial came really naturally to me. It's something I didn't really have to spend a lot of time preparing for or really studying. It just kind of came really naturally to me. You know, my crosses and my directs, they came very naturally to me. The scoring judges just loved me. It's something I'm actually quite proud of. And I won a couple awards, in fact.
Could you name a couple of these awards?
I won Best Attorney Award and I believe Best Cross.
Mr. Becker, why did you join mock trial?
You know, at the start, I joined because my friend Taylor Perkins and I just wanted something to do. It was actually time for us to play on our phones. And as it was something that I kind of realized I was naturally good at. But at the beginning, it was just more to spend time with my friend Taylor.
Moving forward, how did you know Mr. Brockman?
He was the coach of the mock trial team.
And how would you describe your relationship with Mr. Brockman?
Not the best. We didn't usually always get along, which was unfortunate. He always thought that I was lazy and that I needed to work harder, even though I was the most successful lawyer on the team. He would just get mad because I wouldn't usually follow his scripts. So we didn't have the best relationship, which was unfortunate.
And did you receive any repercussions for your lack of preparation or refusing to follow these scripts?
Yeah, so after one practice where I didn't follow his script, he demoted me to the B team, actually, because he was just so done with it.
And did you remain on the B team for the remainder of your senior year?
No, I wasn't on the B team for very long, actually. My friend Taylor, he realized that if he quit, that there would be no reason, that they would have no other choice but to put me back on the A team. And so that's exactly what happened.
Once you were back on the A team, how did the rest of your season go?
It went great. I did great at regionals in both my closing and cross.
How did Mr. Brockman indicate that you performed?
He was less than happy. He went off on me in front of the whole team at the practice the next day, saying how I didn't deserve the award I got, and he said I rely on my good looks, and that I didn't deserve anything, and that I was lazy.
And how did you react to Mr. Brockman's poor reaction to your win?
I was angry. I was upset. I mean, if it wasn't for me, we wouldn't have even been in regionals, and I felt that he didn't fully appreciate it, and I was pretty upset.
Did anything occur after you left that practice?
Yeah, so I've done a lot of dumb things in my life, but I think this was the biggest mistake of my life. I took what I thought was just a dry erase marker, which I later found out was a permanent marker, and I wrote worst attorney award on his Porsche. You know, the plan was just, it would be dry erase, he could wipe it off after, and it would just be kind of my way of just slightly getting back at him. And I found out later that it was actually a permanent marker, and it ruined his car.
Now, Mr. Becker, did you receive any repercussions for the damage to his car?
Yeah, he immediately kicked me off the team.
How did you personally feel about damaging his car?
I felt horrible. In the moment, I was angry, and then I went home and I talked with my mom about it. And at the beginning of our conversation, I was really angry. It was a great conversation because she calmed me down, and I eventually realized that it was my fault. And I had no one to blame but myself, and I eventually felt really, really guilty. I just wanted to apologize to him. I offered to scrub the paint off his car. I offered to work a job all summer to pay him back. I sent him a text apologizing. I tried to go in. After that conversation with my mom, I realized it was my fault, and I felt really guilty.
Did he ever respond to your apologies?
No, which was very sad because I never got a chance to apologize to him before he unfortunately was killed.
Moving forward, where were you the day before Mr. Brockman's murder?
So the night before, I was with Taylor, and we went to the Fry Shack where we actually saw some members of the mock trial team. Then afterwards, we went to the mall, played some video games at Taylor's house, and then I went home.
Did you notice anything strange when you were with Taylor, Perkins?
So the next morning when I woke up, I realized I didn't have my phone. So I went to go pick up Taylor like I always do, and we spent the whole day looking for it. But I didn't realize it until the next morning.
Moving forward, Mr. Becker, do you know Blair Rollins?
Yeah, he was another student at Colorado High School. It was kind of weird, but I knew of him. I knew him decently well.
Would you say that you knew Blair Rollins fairly well?
Yeah, I mean, we spent a lot of time together because we were at the same school. So yeah.
And from a general view and only speaking from your own perspective, how would you interpret the relationship between Blair Rollins and Mr. Brockman?
Probably worse than our relationship. You know, his father, Brachman, Butch Brachman, represented his father on the case that he ended up going to prison for. I know he wasn't very happy with him about that.
One final question for you, Mr. Becker. How would you describe Blair Rollins physically?
Oh, very similar to me. Same height and build. You know, if it was dark out or poor camera quality, anyone could confuse us for each other.
No further questions, Your Honor.
Any cross-examination?
Yes, Your Honor, but before I begin, may I get a brief time check?
You may.
May I proceed?
You may.
You didn't like Mr. Brockman, Mr. Becker.
We did not have the best relationship.
Mr. Brockman never gave you credit for anything you did.
Unfortunately, he always felt I was lazy and that
You thought Mr. Brockman had a big ego.
So I thought he was a better attorney than he was, but that was just my personal opinion.
You argued with Mr. Brockman at every practice.
We would have constant arguments because he would always say that I was not following his scripts, even though I was doing well, and it would lead to constant arguments.
You told Mr. Brockman that he wouldn't know a good cross if it hit him over the head.
Yeah.
After winning the Best Attorney Award at Regionals, Mr. Brockman told you that you did not deserve any of these awards.
He did tell me that, which was very unfortunate. It made me feel bad.
He told you that you rely on your good looks alone.
He did say that, yes.
You became really angry as a result of these comments.
I was, which led to me writing the worst attorney award on his car. That was my breaking point.
Before you did this, you called him the worst attorney in the state.
Mm-hmm.
You stormed out of practice.
I did. I was very upset.
And as you just mentioned, you wrote across the hood of his Porsche Worst Attorney Award in permanent marker and in all capital letters.
Again, the biggest mistake in my life. I was just a young teenager, very upset. And
excuse me, that was not my question.
I made a mistake.
You did vandalize Mr. Brockman's car.
With what I thought was an expo marker, yes.
You vowed that you would get back at Mr. Brockman if it was the last thing you did.
So that was one of the things I said to my mom. But after that conversation, that was my peak of my anger, because then I had a conversation with my mom, and that's when I realized that it was my own fault and I felt guilty. And that's when I started to realize that I needed to apologize, which is why I tried to apologize to him after. That was about
and
the
in
peak
that
of my
conversation with your mother, you lied about the reason why you were kicked off of mock trial.
I did feel I was a little embarrassed.
You lied about the reason why you were kicked off of mock trial to your mother in that conversation that you just mentioned.
Because I was a little embarrassed.
Now, moving on to Taylor Perkins. You were best buds with Taylor Perkins.
We were good friends.
One of the reasons that you decided to join the mock trial team was to spend more time with Taylor Perkins.
Yeah, it was a good way to see my friend.
Taylor Perkins was the reason that you were able to get back on the A team after Mr. Brockman demoted you to the B team.
Yeah, he was a good friend there. He knew that I cared about it more than he did, and he wasn't really having fun at that point anyway. So it made sense for all of us. He wasn't having fun. We weren't on the same team, so
excuse me, that was not my question. My question was, Taylor Perkins is the reason why you were able to get back on the A team, yes or no?
Well, as I just said, yes, he was, because of what he did for me.
Thank you. Now, Mr. Perkins is your alibi for the day of March 6th or the day of the murder of Mr. Brockman.
Yeah, we were together the entire
day. No further questions, Your Honor.
Any redirect?
Just a brief one, Your Honor. May I proceed?
You may proceed.
Mr. Becker, did you express strong regret for your actions towards Mr. Brockman's car?
I did, and I felt horrible, which is why I tried to apologize many times.
Did you do anything besides try to apologize to Mr. Brockman in reaction to your dismissal from the team?
I texted everyone to see if they could talk to him on the team. I offered to wipe the paint off his car. I offered to get a job over the summer to pay for a new one. I really just wanted to apologize. It was sad I never got the chance to. I feel terrible.
No further questions, Your Honor.
Any questions based off of redirect?
Yes, Your Honor. You vandalized Mr. Brockman's car as a form of revenge for the comments that he made regarding your performance in the regional mock trial tournament.
It was a dumb mistake. I did.
That is yes or no. Would you like me to repeat the question?
Oh, yes, I did do that. It was a dumb mistake.
No further questions, Your Honor.
Any further witnesses for the defense?
No, Your Honor, the defense rests.
We'll proceed to closing arguments. Start with the prosecution.
Yes, Your Honor. And I'm just going to wait a couple seconds so that my camera may turn on, Your Honor.
Please wait a couple seconds. I've heard this problem before.
Yes, it's a bit annoying, unfortunately. There we go. May it please the court. Your Honor, members of the jury. My name is Anjali Mishra, and today my co-counsels, Anna Debler, Kaylee Langan, and I represent the people of the state of Colorado. Today, we have brought forth the charge of the murder of Mackenzie Brachman in the first degree and burglary in the second degree against the defendant, Avery Becker. This case today can be explained with the simple story of revenge gone wrong. Mr. Brachman was stabbed in the back in his own home by one of his students, Avery Becker. Now, the prosecution has the burden of proof today, and members of the jury, we have met that burden. We have proven to you beyond a reasonable doubt that the defendant is guilty of murder in the first degree and burglary in the second degree. Now, in this case today, you first heard from the prosecution's witnesses. You heard from Detective Jordan Markowitz, who is experienced in cell phone forensics. She explained how phone records and CDR in Exhibits 15 and 16 indicate that Mr. Becker was at the scene of the crime at the time of the murder. You then heard from Kyle Cusack, a certified crime scene reconstruction investigator who broke down her extremely thorough methods. She told you how the horizontal orientation of the blade only makes sense with her theory of a struggle. She explained how the evidence indicates Mr. Becker murdered Mr. Brachman in an act of vengeance during a burglary gone wrong. Finally, you heard from Alex Cifuentes, a student on the CHS mock trial team. She explained how Mr. Becker often slacked off and how his repeated failures resulted in his demotion from the team. She explained how truly contentious the relationship between the victim and the defendant was. Now you next heard from the defense's witnesses. At the beginning of this trial, my co-counsel Anna Debler told you that this is a story of revenge gone wrong. She warned you to be careful when approaching the defense's testimony because, members of the jury, it is filled with bias and falsehoods. You first heard from Blake Van Owen, who left a job in public service working for the Aurora PD in order to become a highly paid private investigator. His theory of the knife being held vertically makes no sense with the clear horizontal knife wound. On top of that, his justification that the knife twisted horizontally by the victim while removing it makes no sense. Mr. Brachman would have had to push the knife inwards towards his spine and not outwards, which is clearly ridiculous. He baselessly tried to attack the prosecution's case, but his accusations are not substantial enough to provide reasonable doubt. Next, you heard from Taylor Perkins, the best friend of Avery Becker. He claimed that the relationship between the victim and the victim and the defendant was so contentious that it pushed Mr. Brachman to his breaking point. Mr. Perkins manipulated Mr. Brachman by threatening to quit in order to get the defendant back on the team. Due to this relationship, members of the jury, Mr. Perkins is completely biased, and I ask that you disregard all of his testimony here today. You finally heard from Mr. Becker himself. He talked about how he, in vengeance, insulted Mr. Brachman by calling him the worst attorney in the state. How he, in vengeance, insulted and vandalized his car and got kicked off of the team. How he, in vengeance, vowed to get back at Mr. Brachman if it was the last thing that he did. How he finally reached his breaking point. The murder of Mr. Brachman was a simple story of revenge gone wrong. Our duty today is to prove that the defendant is guilty of murder in the first degree and burglary in the second degree, and we as the prosecution have met this burden, members of the jury, and we have proven to you beyond a reasonable doubt. I ask that you find in favor of the prosecution and find the defendant, Avery Becker, guilty on all charges. Thank you.
Defense have a closing argument.
Yes, Your Honor, may I proceed?
You may.
May it please the court, Your Honor, members of the jury, opposing counsel. My name is Sophie Lieben. My co-counsels, Eliza Bachner and Haley Glass, and I thank you for your time and consideration in this case. Now that you've heard the stories of both the prosecution and the defense, it should be clear that the prosecution's case is nothing more than a simplistic, superficial, and speculative story. At the beginning of this trial, The prosecution promised that they would provide you with evidence beyond a reasonable doubt that Avery Becker committed this crime, but that is simply not what the evidence here tonight or today has provided. The defense calls 3 witnesses today that testified to the 3 failings of the prosecution: Professor Van Owen, Avery Becker, and Taylor Perkins. First, Professor Van Owen testified to the simplistic and superficial part of the prosecution's story, describing how the police went with the simplest and most convenient version of the story, rather than following up with another huge suspect, Blair Rollins. You want to talk about revenge? Blair Rollins has a motive passed down through a generation. We heard evidence of this when we talked about Blair Rollins' father, who blamed Mackenzie Brachman for his imprisonment. Imprisoning one's father is a much more powerful motive than a teenage grudge, wouldn't you agree? The superficial part of the police investigation is revealed when we acknowledge the fact that Blair Rollins, a major suspect with a strong motive, is now nowhere to be found due to lack of police investigation. Avery Becker's testimony reveals the speculation in the prosecution's investigation. His cell phone, which is a large piece of the prosecution's puzzle, went missing the day before the murder. In addition to the fact that Avery was nowhere near his phone, the information from the cell tower does not provide a definitive location for the cell phone itself. As Professor Van Owen elaborated on in his testimony and in Exhibit 20, there are a myriad number of ways that the information of the cell towers could be inaccurate. The police could have narrowed that down for us, but as I said, the investigation was speculative and superficial. Taylor Perkins' testimony also demonstrates the superficial nature of the prosecution's case, as Taylor Perkins provided an alibi for the defendant. You also heard the prosecution's 3 witnesses, Detective Markowitz, Kyle Cusack, and Alex Affrontus, who also betrayed the prosecution's 3 failures. Detective Markowitz displayed simplicity and speculation through rampant police incompetence. The police not only lost several photos of blood droplets, but failed to get cell tower communication records or ring video records to back up what they claim proves the defendant guilty beyond a reasonable doubt. Markowitz also betrays his superficial case when we remember the prosecution's burden of reasonable doubt, but the detective failed to follow up on a major vengeful suspect in the case. Kyle Cusack also gives away the speculation in the prosecution's case in his obvious bias against Professor Van Owen, and in this assumption that there was only one sequence of events that could have happened. A flowchart hardly upholds the prosecution's burden of reasonable doubt. Finally, the prosecution called Alex Affrontus, who discussed their blatant jealousy of the defendant. Cifuentes gave us text messages allegedly between her and Avery, but showed the superficial part of the prosecution's story by failing to bring her phone to the police station, replacing her phone not long after, and not providing a timestamp in the messages. It is not the defendant's fault that the prosecution failed to properly investigate this case, instead pursuing a simplistic, superficial, and speculative version of the truth. And a teenager should not be condemned to life in prison when a potential vengeful murderer could go free. Therefore, ladies and gentlemen of the jury, Your Honor, the defense respectfully requests that you acquit Avery Becker, an innocent young man who should not lose his life and freedom due to the prosecution's failure to uphold their burden of proving reasonable doubt.
Any rebuttal close? I believe you have about a minute.
Yes, Your Honor, can I request an exact time check, please?
You may.
59 seconds, thank you.
Proceed.
Speculative, superficial, and simple. I'd like to thank opposing counsel for a perfect description of the defense's case. In this case today, you saw that Van Owen's investigation was speculative. He could not even come up with a valid justification for the orientation of the knife wound. Superficial, like the testimony from Taylor Perkins, the best friend who was clearly biased. And finally, they simply failed to provide reasonable doubt. Members of the jury, the prosecution has fulfilled our burden today. We have proven to you beyond a reasonable doubt that the defendant, Avery Becker, is guilty on all charges. We ask that you return a favor of guilty. Thank you.
If the judges could do their scores and submit them first. And then if they're comfortable, we'll take a moment to allow them to